But we are the Sixth Circuit. And let's say that a decision is made on a law in Kentucky by a federal judge. That can be appealed as a matter of right to a three-judge, to the Sixth Circuit Court of Appeals, where a three-judge panel is set up to hear it. Then they hear it, they issue a ruling, and that ruling becomes binding law for the entire Sixth Circuit, not just the little part of Western Kentucky, but for the whole Sixth Circuit, which is Kentucky, Ohio, Tennessee, and Michigan. And if that decision is a horrific decision, that's really, really bad. Then if the case is taken to the U.S. Supreme Court, and by the way, nobody takes a case to the U.S. Supreme Court. One petitions the U.S. Supreme Court for what is known as a writ of certiorari, which means send us the papers, essentially. And if the court grants that, they grant maybe 20 out of 10,000 a year. It's very unusual granting. They can hear it, and when they make a decision, that's that for the entire country. That's the law. The buck stops there. You may remember the Gore, what was it, George Bush election? W, you remember that? Remember before?
Bush versus Gore? Something like that. Gore
Bush
versus
versus Gore, is absolutely
something like that.
In this case, the U.S. Supreme Court violated long-time tradition, which is that the Supreme Court will not rule on the constitutionality of a state law. That's been the law forever. So the Supreme Court says the Florida Supreme Court doesn't understand the Florida Constitution and essentially elected W President of the United States. Mr. Justice Stevens, now retired, wrote a brilliant dissent on that, which ought to be in everybody's library and a read. Bush v. Gore, read the Stevens dissent. He goes into absolute detail on just why that is wrong. For other things you should have in your library, get the Dover, Pennsylvania ruling by Judge Jones. It is 126 pages. I think about that. I printed out the whole thing and bound it at Kinko's with clear covers and so on. It is a compendium of what is wrong with creationism. He went through it meticulously, every witness, and concluded that the witnesses were lying, the witnesses for creationism, that they were in fact trying to establish a religion, and that's what they were doing, and that was unconstitutional, and he stopped it. Now, Judge Jones, to his credit, was a Republican, appointed by a Republican president and a Christian. And so he had to take terrific flack. Now, people are very afraid to stick their heads up. I know that they're afraid they're going to get chopped off. Well, if you don't do something, you can be damn sure they are. Something has got to be done, and the only way for evil to triumph is for good people to remain silent. And if you remain silent, they will take you out. Okay, that's one of the courts. The other court in Kentucky, you have right here, you have in Louisville, you have district court, which deals with misdemeanor criminal cases and lower order civil cases. Above that is the circuit court, which deals with criminal cases up through death penalty, and lawsuits of any amount over whatever the minimum is these days, $1,500 or $2,500 for the district court. Note that the district court judge is a very different animal from the federal district court judge, who has virtually unlimited power. So that someone went to heaven and said, there's a guy sitting up here in black robes on a throne, who's that? I think Peter said, quiet, that's God. He said, he's a paranoid delusion. He thinks he's a district court judge. United States District Court judge. That's the kind of power they have. A district court judge ordered troops into Little Rock, Alabama to integrate the school. It's tremendous power. Okay, in Kentucky, all of the 50 states are different. You need to understand that. All the 50 states are different. Some of them have similar laws and some of them don't. In Kentucky, you're entitled to one appeal as a matter of right, as you are in the federal system. So if you have a case in the circuit court, as we did with the Homeland Security case in Franklin County, before a circuit court judge, the appeal is a matter of right is to the Court of Appeals of Kentucky, where the case is right now. It was argued on February 24th. They promised us an expedited decision, and we're still waiting. And there is no way anybody can speed it up. We just wait and we see what they do. That's the one where 96 of our elected state representatives and 36 of our elected state senators said that that law ought to be held constitutional, and there should be a ruling that is perfectly okay to say that the security of the Commonwealth cannot be assured without a belief in Almighty God. Isn't that horrifying? People should be out in the streets because our nation was not set up that way. Now, I have gotten so tired of some of these people that I've quit being nice on certain things. And if they make some kind of nonsensical argument, a debate or on radio or TV, I tend to go straight for the jugular. If they say we're set up as a Christian nation, well, sir, do you think you know more about how we were set up than people did in 1797? Well, in 1797, the Treaty of Tripoli was passed. It was started by George Washington, who knew something about how our nation was set up, and was concluded under President John Adams. It was a unanimous roll call vote of the Senate of the United States. What does unanimous mean? It means everybody agreed and the votes were recorded, so we know what happened. And the Treaty of Tripoli says, quote, the government of the United States is in no sense founded on the Christian religion. End quote. Is there anything unclear about that? The government of the United States is in no way founded on the Christian religion, or in no sense founded on the Christian religion. One of the two of these religions. All right, so this was paradoxically, curiously, with the Muslim nation of the Barbary pirates around Tripoli. And yeah, that's the Marine Corps hymn, from the halls of Montezuma to the shores of Tripoli. Okay, now in constitutional interpretation, when you're interpreting the laws of the United States, at the very top is the Constitution of the United States. Under that are federal laws, and under that are treaties. So, if the Treaty of Tripoli says in 1797 that the government of the United States is in no sense founded on the Christian religion, what part of no don't they understand? It's absolutely bizarre. They will change history. President Thomas Jefferson wrote the Danbury Baptist and said that the First Amendment creates a wall of separation between church and state. Recently, the Sixth Circuit, a few years ago, that's your circuit here, said that we grew tired of this wall of separation business. We don't think there really is one. It's not constitutional. Well, yeah, it is too, because Mr. Justice Hugo Black quoted it with favor in an opinion making a ruling on a church-state issue. Now, herein is the problem, that the people who were on the court at the time of some of the great civil rights decisions and great church-state religions are dead and gone. People like Hugo Black, Brennan, it'll come to me. It gets worse. It gets every day. It'll be worse tomorrow.
Thurgood Marshall.
Thurgood Marshall, thank you. Clarence Thomas isn't fit to carry Thurgood Marshall's briefcase. He would be horrified. So these bring up William O. Douglas, that's the other one I was trying to think of. And earlier, Cordoza, who's our law school name for here?
Brandeis.
Justice Judge Brandeis. Brandeis's papers, by the way, are in the University Global Law Library waiting for somebody to write a PhD on what they say. His writing is so atrocious nobody could read it. But you might be able to find out. Mr. Justice and Mrs. Brandeis are buried in the steps of law school. But they're not there anymore. When Madeline Murray O'Hare, founder of American Atheists, took the case to the U.S. Supreme Court in 1963 on the reading of the Bible in the public schools,